welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Thomas K. Chu, a New York attorney. We will discuss his work on estate planning and legal issues affecting older clients. So welcome to the show, Tom.
Thanks for having me.
Oh, the pleasure's all mine. We've known each other for quite some time now. I think you may have been in one of the first classes I taught as a law professor. Am I right?
I think so. And it was one of my favorite classes. I'm sure many professors are, kind of flattered by having, the feedback, but I considered your class in not-for-profit organizations really one of my favorites, and one that as a second career person going to law school, I really threw myself into the readings and following the work, and really appreciated your helping the class and me personally get the insights we needed in a very short amount of time with a lot of reading, lots of different kind of cases. And it's amazing how I've taken that and carried that with me, having had 20 years in life in not-for-profit organizations, then, having really a legal point of view in terms of understanding tax law, the cases that we looked at together, but also, applying the learning to our own lives and thinking through how we would see our careers unfold in those years since then. So it's been great to stay in touch, and thank you for bringing me onto your show.
Great, my pleasure. So Tom, maybe you could start by telling listeners a little bit about yourself and about your practice, and in particular, sort of how you became interested in estate planning and issues affecting older clients.
I was, for almost 20 years before going to law school, in religious not-for-profit work. I worked for the Episcopal Church at the church-wide national, international level. And when I left my last position, I was the director of ministries with young people, children, youth, and young adults, and faith formation. Very kind of specific and narrow position, but also with a lot of responsibility for 7,000 plus congregations around the U.S. and around the world. And from there, I had the chance to start all over and chose Hofstra for law school. And the trigger for me in my own life was that my mother took her own life in 2007, just before I made this decision. And I had the experience of being a client of an estate planner and being trustee, executor on the kind of consumer side of this work, and thinking through the entire process how the person who was serving as attorney had the correct academic background, was just fine as far as a professional practitioner, but had absolutely horrible, I'm putting air quotes, bedside manner. Really not a nice person, and not someone who really had a lot of empathy for me, the client. And so through that whole process, I was thinking, you know what? I can go to law school and I can learn how the rules work and regulations, and I can just start out by being nicer than you. And that was really my guiding kind of thought in terms of how I would take to law school. So I was very different from other students who were much younger. I was 40 when I started. So I was much clearer about my personal goals when I went to Hofstra. And turns out that it's a place that is a leader in trust and estates study, and is the home of the ACTEC Law Journal, which is the American College of Trust and Estates Counsel. So I was fortunate to be around some of the most highly regarded minds and teachers in the field, and in a relatively small law school environment, and in a very narrow field of estate planning, which is not necessarily the most popular choice. So I got lots and lots of attention from wonderful and encouraging professors, and was able to kind of map out my own journey through that process. And in fact, in exploring my academic interests, I found that there really was no work in elder law, which is a specific related field which focuses on the needs of elder clients and what's called Medicaid planning, asset protection planning. And it's a very specific practice that is done differently in each state because of the way the Medicaid program works to help middle-class patients, clients qualify for Medicaid through a process of self-impoverishment, which is a very kind of very specific practice, and which is something that it's called elder law, and it does include some of the areas that I'll be sharing with you in this podcast. But I actually, to find out more about this, decided to be the founding officer of the Hofstra Elder Law Society. And at the time, it turned out that a former dean of Hofstra was really the founding thinker in this field, which only goes back to the 1980s. So it's actually a relatively new area of legal practice and legal thought, and it's specifically applying the law around people in their older years, and that's specifically Medicare and Medicaid, as well as disability law, and then also thinking about end of life or healthcare planning. So I've decided to focus in my practice not so much on that specific Medicaid asset protection planning, but so that's what, when people think of the term elder law, it's what they're thinking about. But I did actually spend quite a bit of time doing that discernment in law school. And so Hofstra was a great experience, place to try things on, meet practitioners, really to find out more about how that would be come out in practice. And so I had some really wonderful professors guiding me, but also practical experiences in my summers between semesters to really work in offices to find out more. And so coming out of law school, once I got admitted to the bar in New York, I was ready to launch a solo practice. I went straight to solo from law school, which is pretty unusual, I think, for most people. I did have the backing of my family to take that gamble and spent my own resources which I'd saved up to go to law school. So I was privileged in certain ways to choose my own path in that way. But I used the 4 years in a part-time program to discern a path forward as an estate planner. And so since 2013, so going on now 6 years, next month, I will have had quite a few clients to have worked with, to tuck under my belt, and it's been a real joy for me. It's a very special area of practice in that even after the engagement ends with a client, my work continues really through whatever ups or downs happen in that household, but also beyond death. In fact, helping to do probate administration, working with survivors, executors. So it's a commitment that I make to a client in their household for really even past a generation for their lifetime and then into the future. So it's been it's been a choice that is a very specific practice of law that's very personal. It crosses from legal into financial, which planning, which I do a lot of, and it's really covering a number of topics that people hold very closely to their chest. So it takes gaining confidence that I'm able to bring from my other work to help people find out, get clear about what they want, and then for me to help cement their wishes in writing and help them understand how the law can serve their needs.
So, Thom, in your experience, what are like some of the most common misconceptions that people have about estate planning and the estate planning process, or maybe like the most common mistakes that people make when planning their estates?
Sure. The first thing that I'll hear from people is something like, "Well, Thom, I don't really have much or of anything to really have a plan for." And my response to a person who says that is that anybody who has anything in their life, whether even if someone says, "Well, I'm alone in the world, I'm single," even if somebody lives very simply in their imagination, in their estimation, will have obligations, financial obligations to wrap up if they, and when, frankly, they die suddenly, right? We don't know when, for most people, we don't know when that's going to happen. But even somebody who, say, rents an accommodation and only has debts to pay, still has an estate and still has to have somebody needs to step in to stand in the shoes of that person when they die. So that's probably the biggest misconception, is that many people think they don't have that much to be worried about. But even somebody who conceivably, thinks that they may have a negative equity may still have obligations, a last rent bill to pay. Somebody needs to clean out an apartment. Certainly when a potential client has children, they have a lot at stake, because if there's a sudden disability or death of one or of both parents, then a child is without custody, and then the state will step in and choose a guardian on their behalf. So that's probably the biggest misconception, is that people think they don't have enough to worry about. But I think everybody has something that they should be worried about. I even, help parents of older teenagers think through what it means for someone to turn 18 under the law. When a child reaches the age of majority, parents no longer actually have control over the child's healthcare decision making, the child's personal finances. So I will do healthcare proxies, or in some states they're known as medical powers of attorney, or financial powers of attorney. I will do those documents for young people who are turning 18, even if they're living in the same household, because if they suddenly become disabled, the parents don't automatically have legal rights to make determinations. For instance, even if the child is under their insurance plan, it doesn't necessarily give the parents legal access to the adult child's healthcare information, for instance. So that's another misconception, that people might think, well, I'm too young to have an estate plan. So once somebody reaches the age of majority, a lot of these decisions should be made. Maybe an 18-year-old doesn't need a will if they don't have any assets, but a parent should have at least a will for a guardianship to be designated by will in case there's a sudden death. Now, if there are two parents, the surviving parent would have already, guardianship privileges that come from their biological parentage. But in some cases, there's more exposure because there's only one parent involved, or one parent with custody involved. So that's another kind of misconception that people might have, to think that, oh, well, I don't have that much to worry about. But the other big misconception that people have is the idea that an estate plan is only for after I die. And as it turns out, the Social Security Administration predicts that a 20-year-old today, who has then 47 years till 67, till their retirement age, they have a 1 in 4 chance, 25% chance of having a disability that will take them out of work for 90 days or longer. And that period of disability, is 90 days or longer, is long enough for someone who doesn't have an estate plan for disability to miss a payment on a loan, or miss a rent payment, or go into arrears on other debts that can leave them seriously not only disabled but also out of a home, right? So if there's a 1 in 4 statistical chance that's what the federal government is using for their measure of the likelihood of disability, this is a wake-up call for all of us to plan for that possibility. It's, and in this case, 1 in 4 is a probability of one, so it's something that we just don't know when it's going to happen. And if we don't have a power of attorney for money and finance, or a healthcare proxy, or a medical power of attorney for when we can't speak the words that we wish to a healthcare provider, we could really wind up being in a really deep trouble, because there is then really what I call the null plan, right? Of what actually not making a plan has consequences, and the law will fill in the gaps. So in all states, there's a law of intestacy, of what happens when one dies without a will. And then also there are laws around disability and what happens, guardianship, or some states they call it conservatorship. What happens, how does the state fill in the blank when there is no person appointed in advance to take care of medical needs or health or economic needs?
Well, so when people are planning their estate, what kind of options or choices that they have? I mean, I'm familiar with like the idea of obviously like drafting a will and so on. Is there just like one kind of will, or are there other ways of approaching estate planning?
Right. So at the very minimum, I think everybody should have a will, because that would allow the testator, the principal, to appoint someone in advance who will stand in their shoes to take care of business. And all kinds of things can happen that people may not even anticipate, right? If there is a cause of death is because of a tort, or a hurt, an accident, or the cause, caused by someone else, there could be recovery by the estate, where you want the executor to be able to hire a lawyer, go after someone who committed the, misfeasance, malfeasance mistake, and make a recovery. It could be a medical malpractice. It could be a car accident. There are all kinds of causes of death that actually could trigger actually more money coming into the estate. Or there could be a lawsuit that happens during lifetime but doesn't pay out until afterwards. Could be an insurance payout, could be a tax payout. So, or even money left in form of bequest to now the person who's a decedent. The person dies, somebody can stand in the shoes. So that will be a typical way of managing that. And certainly, everybody should have that. Some people choose to have a trust set up, which would be an optional possibility, which allows a client to really kind of create what I call their own law, their personal set of rules of how their assets can be managed, both during their lifetime in case of disability, but also after death. And then they can really kind of, rule from the grave or from beyond, and set up provisions that can last beyond their immediate kind of distribution after death that would a normal kind of a will might have. And there are trusts that actually live inside of wills. They're called testamentary trusts. And that may be useful I do that for families with young children where the likelihood of both parents dying is kind of remote. But for some people who may already have a disabled beneficiary, or there's a possibility they have enough beneficiaries out there that one of them may become disabled in future, that it can be very, very useful to set up a trust, because then they can do things to supplement but not supplant benefits that may be flowing to the disabled person. And so anybody who's on Medicaid or Social Security disability or other government benefits might find themselves, if the money is coming to them in form of cash through a will, may find that they've become disqualified by their assets getting too inflated to qualify for those benefits, which for people with disabilities can be really spoil their situation. It might be in the end of their housing benefit or important medical benefits that they rely on. So trusts can really help benefit a whole range of wishes, especially for disabled persons or beneficiaries, but definitely for clients who want more control. Say if they want to benefit other generations of descendants or charities and so on, they can have lots more control through a trust. And basically within the law, I can help people craft an approach or a solution for problems they might see cropping up once they're no longer there to make decisions. So I can kind of stand in their place to be the arbiter of certain kinds of economic decisions, not so much healthcare. This is really about how assets are distributed. But many people think, oh, Tom, I don't have enough to really worry about that. And when I actually help them think through their situation, it's amazing how complex households can get when there's blended families, for instance, when there are a second marriage and two sets of children, for instance. There may be we wish to care for children from different marriages and care for them differently with different assets because they may be flowing from different sources. I learned so much from my clients because they come to me with their issues and really what I think of what issues forth from their lives, right? And I'm able to help them understand how the law can serve them. But those are some examples of how people might think of a trust versus having just a will to achieve their goals. But I'm not one who's interested in just selling people another piece of paper. just to do the work. It's really more about helping them understand how the law can serve them. And then for people with lots more assets, if they're worried about estate tax, there are ways to deal with that possibility. Right now, the federal exclusion amount is well over $11 million. So the number of households they're going to have to pay an estate tax right now is quite small. So that's really not the core of my practice at this point. But in New York State, estates of over about around 5.5 million are subject to some tax, and so I can help people plan for that, and trust can help with that by moving assets around using the tax law and the laws that are available today. But the trust can be very, very useful to help give shape to plans that are extending well into the future. But a trust can also help people make charitable intents, maximize their charitable intent by getting some great tax benefits along the way, or dividing kind of assets in a way that both benefit human beneficiaries in a lifetime or maybe later, and also help a charity and get some great both recognition, but also some great tax benefits. So it's fun to help people who are charitably minded kind of understand how the rules work and help them really play the game and get kind of the best result.
Well, so you mentioned the use of trusts in estate planning, and I understand that, among other things, trusts can help people avoid probate. I wonder if you could talk a little bit about why that might be advantageous, and also whether there are any particular risks potentially associated with using a trust in an estate planning context.
It's useful to have the probate process varies in terms of the expense of probate and the time it takes. And so some attorneys will, sell the idea of doing a trust by, kind of contrasting kind of what it costs to do the work later. In the end, when you set up a trust, it's kind of, I think of it as, in simple terms, pay now or pay later. So when you can fund a trust in lifetime and set up the rules in advance, you can avoid the probate process. And probate's fees are based on the size of the estate. So for people of modest estates, it may not, on balance, be in terms of cost and benefit. It may be, even. The difference is that there is time involved in probating an estate. A state has to stay open for in New York State, it has to stay open for 9 months until we're able to distribute the assets to the eventual beneficiary. So a trust can actually work more efficiently because those assets can be distributed more quickly. And so there may be immediate needs where it's actually quite helpful to have it all under control of a trust. But for some people, I will work with them and help them decide which is the best approach. But I think a well-drafted trust according to the jurisdiction where people live, there aren't too many risks if it's correctly drafted and executed. There are, whenever people change their domicile, the law of wills and trusts is governed by the states. So when a household picks up and moves somewhere else, the plan needs to be examined under the lens of the new place of domicile, meaning the place where you choose to live without, with no intent to move on to someplace else. So I have had clients who moved from New York to California, and I suggested an attorney over there, and they had to pay for a plan, and then they moved back to New York, and now they have to pay for a New York plan because New York and California actually have different sets of laws. And so there are, in the law of wills and trusts, there, in terms of property, there are some states follow something called community property for married couples. And it's very differently structured than in New York, which is a separate property state. So what happens in community property states is that when people marry, that actually the character of the asset actually merges. And so it's pretty complex for those of us who don't come from those jurisdictions to navigate. And so it's important that people, whenever they move, they need to, for whatever the time they put into and paying for their plan, they need to get an advisor or an attorney admitted in their new state of domicile to take a look at what they have and make sure it works. Sometimes what has been drafted in the prior jurisdiction may work. In general, it's not. It's much more helpful to make sure that everything fits together if they're intending to not leave, and that there would be a death in the other jurisdiction, because there can be unintended consequences that the first drafter won't have known, because I'm only qualified to draft for my own jurisdiction in New York. So so there are some risks in terms of, whenever people put a plan together, they keep it up to date. So whenever there's a change of residence, and then obviously whenever there's a change in the household composition, it could be a birth, it could be a death, it could be substantial, bequest coming in. Any change of status in the household really merits visiting the advisor again, coming back to the planner and seeing if there are things that should be attended to.
So, Thom, I was wondering if you could also talk a little bit about end-of-life issues, so sort of non-financial estate planning, but planning for the death process. Are there things that you think are important for people to know and to think about and to contemplate in relation to end-of-life issues?
Absolutely. I think that, disability can hit us really at any time in life, and it may be a temporary disability. So in terms of healthcare planning, having an advanced, the terms are different in different jurisdictions. In New York, it's called a healthcare proxy. Many states use the term medical power of attorney. And these are documents that clients can have drafted to make their wishes known in writing, so that they appoint a person to stand in their place in case they're not able to speak their wishes to a medical professional about how they want to live with medical, technological assistance, their attitude towards life support. It's really important that they have that conversation with their agent. And I do have clients who ask about living wills, which are, in New York, is not a living will state, but some states do honor documents that people have drafted in advance that really do document put in writing their wishes as far as attitudes towards, say, massive antibiotics or pain medication, pain management, number of different possibilities. But it's really impossible to plan for all the permutations of what can happen to a person. So it's really important to have that conversation with the agent, have a backup agent, have those people be very available, have those papers filed in advance with healthcare providers. But another wrinkle in all of that is that there's a federal statute about health information privacy, HIPAA. And it's a very, very important law, which, by the way, many in the medical profession really overinterpret and over-defend the information of patients, even from the patients themselves, and sometimes to the people they want to have act as agent. So I draft an authorization to make sure that those people are authorized in advance to get information like patient charts, blood work, X-rays, MRIs, those very important documents that an agent would need to understand before making a decision on behalf of the principal. So that's one piece that I think everybody really needs to attend to. But I think that the frontier of work around healthcare proxies, medical powers of attorney, is around care in case of dementia. So I've been working with an organization here in New York called End of Life Choices, and the organization has developed a really nice document. It's called a Dementia Advance Directive. And there's just a growing demand from patients wanting language that's not adequately addressed in the statutes, in this case in New York, around healthcare proxy, around making wishes known, around specifically oral assisted feeding. So the issue is this, that there is an autonomic response that if you see babies getting kind of conditioned to be fed, that actually is actually triggered by bringing a spoonful of food to the lips. And so there's this whole kind of neurological response. And then there is a reaching out, lips touching the vessel, swallowing, masticating, but it may be actually quite involuntary for people with advanced dementia. So what the directive does is it has very specific language to instruct the healthcare provider to be super attentive to the patient giving signs of either pleasure or displeasure, rejection of food, so the patient still has a little bit of control, even though with advanced dementia, people are nonverbal, to be able to signal to the healthcare aide, person doing the feeding, that they are not really enjoying being fed. Because that's the very little bit of control that a patient has left with that kind of situation. And people can live for a long time. We talk about, being kind of very well below the brows. The heart and the pulmonary function and the digestive function can all be, going very well. And yet people can be living with advanced dementia, not even know where they are, who they are, and live for a very long time. But it's very important that we give patients the dignity of having choice, and in this case around food. And that's, I think, a frontier of work that I know that we're doing here in New York, and there are other states where there's quite good work going on. There's a lot of work going on with dignity in dying, where there is there's some work I know Washington and Oregon states. There's been very good work done to allow people who live in those states to actually plan for dying with dignity with the aid of a physician, and each state has done it a different way. But there is another alternative for those of us in states where there is not yet this legislation, and so another edge of the work that's happening that I've been following very closely, because my clients do bring this to me as patients of doctors asking, well, what can I ask my doctor to help me with? There's actually quite a nice article that appeared just a couple of days ago, early in November, in the Washington Post. And I'll just read you the title. At 94, she was ready to die by fasting, and her daughter filmed it. You can Google this article on the Washington Post website. And it's about a person who at 94 was ready to die, and there really was no medical aid to die, but she chose to die by fasting, was able to get hospice help to kind of give her pain relief in that process. And her daughter actually filmed it as a way of documenting what actually does happen. It's not an easy way to go, but these are people who are making their own choices. And as an attorney, my job is to really kind of vindicate and defend the position of my clients. And in this case, these are people who are making very specific decisions about how and when they want to die. When they find out that they have a terminal illness, they're not able to really enjoy life anymore. They've tried the possibilities, and they're asking for help. And I think that those two pieces of work around the Dementia Ambassador Directive and dying through fasting are really interesting areas. And there are lots of ethical questions around this, but the people are already mapping out this territory, and I see my role is to really help my clients find out how the law will serve them. And in this case, I'm not able to give them a lot of advice, but to just report to them what other people living with terminal illness are actually trying out, and how the law is treating it.
Well, so Thom, in closing, you mentioned earlier that before going to law school, you had a long career in the charitable sector, and specifically in religious charities. And I was wondering if you could reflect on how that period of your life and your work in the charitable sector and your religious faith have informed your practice as a lawyer.
That's a wonderful question. No, I think of it often, in that I still bring my religious spiritual conviction to my work, but I'm very aware of the fact that my clients are coming to me with very specific personal needs. But I think of my purpose in the world as being kind of very much in a continuation of what I'd committed my prior professional life to, which was serving an institution in a particular way. Now I'm really focusing it on individual clients, which is really helping people to get clear about their values, what they really want in life, and in this case, life and death, so that they can match up kind of their core values about what matters most to them with what they have and how they want their assets to be distributed, but also how they want their values to really be extended through their decision making, including in many cases, many of my clients do have charitable intentions, and I'm able to help them act out their intentions in ways that can get them recognition in a lifetime. Sometimes they want to act anonymously, but really get them a great result. And so I think of being able to kind of live a full humanity of doing something where I can bring some expertise to a situation and help serve people and help them kind of get clear. That's the biggest part of what I do, is really help people find clarity, and then once they have the clarity, to make sure that they get it documented, and that I can kind of waterproof that, against challenges in the future. So I find that there's like a real continuity, and through my mother's own taking her life and my own experience as a client, that I really took that experience and the values that I had then, and really try to embody the best practice of serving as attorney to help people. And so it's something that does inform my life, I think, in a small way all the time. And it's certainly been a cornerstone of my practice. Even, many of my clients are not necessarily religious or even spiritual, but they sense a compassion in me and are attracted to me for the heart that I have for the work that I do. And it does take quite a lot of capacity for empathy to help walk alongside clients who are facing, all of these ultimacies in life, about disability, about death, all these kind of big, kind of capital letter things in life, which frankly, most people don't want to really think about too much, right? So by the time they get to me, they've thought enough about it to say, I want to put pen to paper, I want help, and they're quite open, and I'm able to serve them in a way that's meaningful to them. And it's a joy that, for me, that I am able to make a living in that practice and help people in the way that I can.
Oh, great. Well, thank you so much, Thom. That was really a beautiful sentiment, I think, and it's been really informative for me, and a delight to talk to you about your practice and these really important issues that I think people really need to be thinking about.
Well, thank you so much for having me. It's wonderful to get to share with you and catch up. And now I have to go back to your list of podcasts and catch up with others of your guests.
They'd hooked you up to a fentanyl drip, to mitigate the pain a little bit. I flew in from Pennsylvania, when I heard the hour was coming fast. And I docked in Santa Barbara. Tried to brace myself, but you can't brace yourself when the time comes. You just have to roll with the blast. And I'm an 18-wheeler headed down the interstate, and my brakes are gonna give, and I won't know till it's too late. Tires screaming when I lose control. Try not to hurt too many people when I roll. find the harbor freeway and head south. Real tired, head kind of light. I found Telegraph Road. I'd only seen the name on envelopes. Found the parking lot and turned right. I felt all the details, carving out space in my head. Tropicana's on the walkway, neon red. Between the pain and the pills, trying to hold it at bay, stands a traveler going somewhere far away. And I am an airplane tumbling wing over wing. Try to listen to my instruments, they don't say anything. People screaming when the engines quit. I hope we're all in crash position when we hit. And then came to your bedside. And as it turns out, I'm not ready. And as though you were speaking through a thick haze, you said hello to me. We all stood there around you. Happy to hear you speak. The last of something bright burning, still burning. Beyond the cancer and the chemotherapy. You were a presence full of light upon this earth, and I am a witness to your life and to its worth. It's 3 days later when I get the call, and there's nobody around to break my fall.